Well, good afternoon. My name is Ala McCoy. I'm Director of Startup Support at University of Maryland Inventors, and I would like to extend a warm welcome to all of you who joined us today for the next installment in Startup Fundamentals Workshop Series, both live webinar audience and those watching a recorded version on our Startup UMD YouTube channel. This workshop series is offered by Inventors at the University of Maryland. To everyone attending the live session, please feel free to submit questions using the Q&A function. You should be able to find it at the bottom of your screen. Since we are recording this session and posting it online, you will be able to submit your questions anonymously if you wish to do so. So today's session, we will cover common mistakes startups make in their IP strategy and how to possibly prevent them. I'm pleased to introduce today's speaker, Dr. Keisha Hylton-Rodic, who is an entrepreneur herself. She's a registered U.S. patent attorney with a Ph.D. in organic chemistry. She specializes in assisting venture capital funds, angel investors, biotech companies, research institutions, pharmaceutical companies, and chemical companies with growing their domestic and foreign patent portfolio, as well as strategic portfolio analysis of patents in the biotech, pharmaceutical, chemical, and paper spaces. She also assists clients with patent-related risk assessments, including freedom to operate, API clearances, due diligence, patentability assessment, infringement, and validity. So thank you so much, Dr. Hylton-Rodic, and thank you for joining us today, sharing your expertise with us. So the microphone is all yours. I'm gonna turn off my mic, but I'm here, and I'm gonna turn off my video so you won't see me. And unfortunately, you won't see the audience because it's a webinar, but I'm here, and please, everybody in the audience, keep submitting questions. All right, thank you.
Thank you, LA, and welcome everyone. Such a shame I can't see you all in person, but I will go ahead and get started. And as LA indicated, please feel free to ask any questions you may have during the session, and of course we'll have opportunity to have a full discussion towards the end. So for today's presentation, it will be somewhat informal insofar there won't be slides. It's more in my mind of a conversation. So let me go ahead and get started. Now, I would say, you know, when startups kind of first take that first step towards entrepreneurship, you know, most people kind of think about, well, you're going to be that next Apple or Pfizer, you know, whatever that kind of big player in the space, you know, and so in that regard, one has to really be able to position themselves on the IP side to be able to take the next step in terms of kind of growing that business and being able to best position yourself to attract investors or to have the technology, for example, licensed. Now, when it comes to divesting, you know, in those years to come, the size and the quality of your patent portfolio will actually be very important to any future suitor or, you know, investor. And in many respects, it will actually impact the survival of your fleggling venture. And most people will say, well, already that's not news. But one thing one blind spot that I see quite often, especially with startups, is that, you know, most people just think, well, I just need a patent, right? And they don't really think necessarily about the quality of the patent, the coverage of the patent in terms of being a useful instrument or vehicle in really protecting the innovation and also enabling that startup to be able to achieve these business objectives, right? You know, one thing I always kind of caution for those startups that I have talked to or inventors, for example, in the university setting, thinking of doing a spinoff, right, is that having a patent that will survive rigorous scrutiny is important. So in essence, having a patent is one thing, but it's really, really, really more important to have a patent that will survive rigorous scrutiny by a competitor looking to copy your product, right? Or playing your space, or a suitor or an investor looking to put money on the table, right? That's very, very important because, if your patent is not well drafted and it's vulnerable, then it means then that you have a higher chance of actually having your patent invalidated, right? The other thing to think about is, aside from really the vulnerability of the strength of the patent, is again coverage. I've seen, usually when a company is, for example, looking to invest in your venture, one thing they're looking at is, does your patent actually cover the commercial embodiment? What is it that you're going to get to market? And so that's also a very important consideration. So you have to really keep those things in mind when you're really thinking of, okay, I am investing time and money into really developing a patent. And I think one of the things that I would say one of the mistakes that I've seen startups make, for example, and sometimes independent inventors, is that they will just kind of go online and they're like, you can get a patent for $500. Some random person can draft it for me for super cheap. And what they end up with is really an expensive piece of paper, because quite frequently those cases are not done very well. And unfortunately, when it comes to the patenting space, it's usually, you don't really know the problems you have with a patent until sometimes years later, when maybe you have a prospective investor come along and they have to do their own due diligence before they actually choose to invest. And then you discover, oh, the patent actually is flawed, or the patent application is flawed because it doesn't cover the product or the method, for example. And it's not just a claim issue, but maybe there's just no disclosure at all that kind of captures the invention. Or sometimes there are actually what you may find, certain vulnerabilities that, because it was not drafted well, you kind of run into. So those are, I would say, one of the mistakes that I've seen. It's really kind of penny wise and pound foolish. And there are ways to get around issues like this, in terms of where you don't have those funds to be able to go out and say, okay, I want to get a certain firm to do my drafting. There are many firms that are willing to, for example, if you can assist with the drafting, insofar as sometimes what I find is that inventors kind of really know the technology and they're able to kind of draft up certain portions of the application, and then kind of really work hand in hand with a patent attorney to really refine the application and make sure that everything is in place. So there are ways to kind of get around that cost consideration versus just kind of going, on Google and finding some random person to draft something that you don't know the quality of your work product. So, that's one thing I want to highlight. But before we kind of get into the weeds of really what you should do, just wanted to kind of do a quick overview of the different areas of IP, just generally. I know that it's my understanding that this is a series, so you would have had some previous sessions covering IP. But I just want to touch on a few things before we kind of delve into just kind of more practical advice. So a patent is a type of intellectual property, and that's kind of really the focus of our talk today, that confers a legal right, or, in another way of saying it, a property interest to exclude others from practicing your invention for 20 years. Now, patents are actually very valuable in terms of really what the protections and it confers to a business venture, right? And that's why companies, for them, the IP is really a very, very important asset as they kind of hedge their bet and decide how they're going to unfold their business strategy. So one of the strategic advantages of the patents is that it makes the company valuable because it's property, it's an asset, right? And it's an asset such that you can actually borrow money against it. There are some companies that choose to obtain security interest against their IP, and so it's definitely it's valuable, right? And that's why, as you think of really developing that asset, it's important that it's done well, right? Because as you really try to enforce it or use it, it's going to be scrutinized and see the quality of what you have. As I mentioned before, it can be monetized. That's another advantage via licensing or sale to provide revenue for the company. It can be used as a collateral. It also actually reduces the risk of your technology being stolen as you try to shop your technology to partners or investors. That's actually, I would say, one of the primary reasons that most there are a lot of startups thinks about a patent, because they may come to us and say, well, I'm planning to talk to this individual about possibly investing in our technology, or maybe even kind of collaborating on further work to refine the technology. We have an NDA, is that enough? Or, do we need to do something else? And I always say, get a patent application in place. Doesn't, even if it's not completely fully fleshed out, it could be, I advise against cover sheets. And I won't go into the details today. Don't want to kind of take us too far off track. Typically cover sheets don't provide the kind of protection that people think they're actually about to get. But certainly there are, between a fully fleshed out provisional case and, the opposite end of the scale is a cover sheet. There's much you can do in between those two extremes. But certainly having a patent application in place when you go out to try and shop your technology is critical, because what has happened time and time again to innovators is that they may not have the resources in order to take their technology to another level. So they will try and go sometimes to a bigger player, sometimes even to like a contract research company, for example. And what ends up happening sometimes is that somebody basically copies their idea, maybe make some changes to it, and they, for example, run off and try and patent that technology. And because maybe they only had an NDA, which only can provide protection oh so far, there's really very little that you can do at that point. Certainly there are procedures, in the patent office that you can really try to demonstrate that it was stolen, but it's better to actually have something in place, and you're trying to now, after the horse is out the barn, you're trying to close the doors, but it have the door closed at the beginning. So that's one thing I would definitely highlight in terms of one value as you think of shopping your technology. The other advantage, what I've seen in my practice, is that having a patent application, at the very least, a lot of VCs and other investors actually take the company way more seriously, because in their mind, you have kind of put money behind your technology, and so it's easier for them to say, oh, these people are serious about what they're doing. So that's also a benefit of really at least filing a provisional before starting to shopping your technology. I won't go into a lot of details here on the other areas of IP, but I'll just kind of highlight them, because you should definitely think about those as you really think of developing IP generally, not just only patents. Trademarks or a service mark. And that's a legal right that precludes others from using any word, symbol, sound, device, or combination thereof that you use as your company to distinguish your goods or services from others in the marketplace. And in the US, you can obtain a trademark or service mark under common law, state law, and or the federal law. You can also obtain trademark and service mark in various foreign jurisdictions as well. So typically the trademark is useful because it helps you to control your brand. And also it provides, more importantly, a legal instrument so you can go after those who actually want to copy your trademark, right? So maybe you have something that's, Acme batteries that you have developed, right? And you have marketed it, and you have a trademark that if somebody tried to really have a spin-off, maybe they call it Acme batteries, and it's really your technology that you really kind of copy, then having that trademark gives you the legal right so that you can actually, for example, have somebody take that down from the website, things like that. You actually have something that you can take, for example, to Amazon to say, you can't sell my stuff there. It needs to be removed. The other type of IP is copyright, and that usually, that protects works of authorship, including writing, software, and music. You can have copyright in the software space. So usually copyright patents and copyrights can be used under certain circumstances to protect software from theft. And each type of IP, protects a different part of the software. So for example, the patent would protect the idea versus the copyright could protect the actual written code. And there are advantages and disadvantages of both that go beyond simple legal protection. So for example, software patents are typically very difficult to get. Copyright, on the other hand, may not protect the software in the way you need. But again, I don't want to go too far in the weeds. I want to reserve our time to discuss patent issues, because I think those are probably the most pressing in terms of as a startup kind of gets moving in this space. There's another IP, type of IP that a lot of people don't really think of as an obvious mode of protection, and that's trade secret. So trade secret, as the name suggests, is a process, formulation, or know-how that a business chooses to keep secret. And I would say probably the most famous trade secret is probably the Coca-Cola formulation. Everybody think of Coca-Cola when they think of trade secret. The challenge about trade secret, though, is that it must stay secret. So there needs to be strict internal SOPs or standard operating procedures to actually keep the information secret. You actually would need to have employees and others in the business sign an NDA with penalties to deter theft. So trade secrets are useful a lot of times for example, method kind of based inventions, because there's certain inventions that the patents may not be the best fit to get that protected. And so some companies choose to keep it as a trade secret, but trade secrets have its own vulnerabilities. So, you can have issues with theft where, you have industrial espionage. And so you basically have that right almost basically lost. A patents usually kind of give you a stronger protection, but it's not always appropriate. It varies depending on really what you're trying to achieve. So what's the best IP for your business? That is going to be dependent on the circumstances and what your overall business objectives. So that's something that you want to maybe talk to a trusted IP lawyer or a patent lawyer, for example, or usually, trademark lawyer. They'll be able to kind of give you some kind of guidance. So I have a few examples I have here listed in my notes. So for example, let's say we have a company that has a core tech is in the alternative energy space. Example, they have a new product, they have a battery. So their IP strategy may make sense to have a trademark to, for example, protect, the name of the business, literally the name of the business. Could be if they get far enough to have a product that they will have on the market to protect the product itself. They may also have trade secrets because there are certain manufacturing methods that it may not make sense to actually have patent protection for that, so that they may keep that as a trade secret. But again, as I mentioned before, it would be important to make sure they have certain procedures internally that ensures that it stays secret, and also has certain deterrents that prevents this information from being stolen. It would also make sense to have patents as part of their overall IP strategy as well. So I wanted to, in the time remaining, kind of touch on some what I see to be some areas of vulnerability that I've seen over the years, and then I'll open up for questions, because I really want to give the audience a chance to really field some of the questions, and then we can go into a more robust discussion. So one area of vulnerability that I've seen in the past is publicly disclosing the invention before filing a patent application. So as someone who has scientific publications myself, I'm aware of the appeal to publish. However, publishing or presenting at the next ACS meeting, monthly department meeting, otherwise this public invention will have some serious consequences, especially if you would like to pursue a global portfolio, which a global portfolio is actually very valuable, depending on the technology and really business objectives. I would say valuable just generally, irrespective of technology. There's certain kind of business realities and circumstances where it probably makes sense to just have a domestic portfolio, but I would say on average, if you can go in international, you probably should, right? But again, it would be good to have an IP advisor really kind of guide you in terms of what's the best next step. So now, by publicly disclosing the invention before filing, you may be unwittingly closing the door to obtain patent protection abroad. Because usually once you publish, in most jurisdictions outside the US, it's just a cutoff. You just cannot file anymore. US, for example, provides a 1-year grace period, which again has its own limitations, so that you wouldn't lose patent protection domestically, provided you meet certain conditions and you file within the 1-year period. The other pitfall that I've seen over the years is selling or attempting to sell the invention before filing. So money is tight and you need to secure funding as soon as possible. Well, if you're selling or attempting to sell the invention before filing, it may preclude you from preclude you from obtaining patent protection in the US. Therefore, again, this is one more reason why it's important to file, before you go and shop your technology, right? So, to kind of reiterate, before you shop the technology, filing is important because for at least 3 reasons. You don't close the door to obtaining patent protection in the US and possibly worldwide, because you may run into issue of public disclosure as you attempt to really kind of sell the technology. The second is that you would protect yourself from any suitors who may try to steal your idea. And again, as we talked about earlier, having patent pending will make your application, your venture more attractive to potential investors. Another pitfall that I've seen is where the startup fails to get assignment from all the inventors while the going is good, so to speak. It is very important to have all the inventors, including the co-founders, sign an assignment while still with the company. Failing to do so may create a legal predicament after. So basically, each inventor has essentially 100% right. So they can go off and, assign their right in the invention to a competitor, let's say, for example. But if they assign their rights to the invention at the beginning, to the venture, then you don't really have this problem. And a lot of times when feelings are going well, people will sign the assignment. But sometimes, relationships sour, and somebody who would have been happy to sign at the beginning changes their mind and says, I'm not signing anything. And then you have a quandary at that point, short of you having some agreement in place that you could say, okay, this person did have an obligation to assign. And you can try and invoke that in terms of really has a workaround about that, against that person refusing to sign. But so it's important to sign the assignment basically at the very beginning. And also to have an agreement in place that clearly states and lays out really the obligation of any inventor to assign their rights to the venture. And before I move on to the next topic, I would say as a parting word on assignments, it's important to actually include language, this assignment language about obligation to assign in all employment agreement. That's critical. And I would also add that in, for example, the case where you have like a contract research organization that's working on your technology, you want to make sure that there is language in any agreement with that CRO that anybody who works on that project, an engineer, on a scientist, they need to make sure that they're assigning back to your company. That's going to be important as well. Another pitfall that I've seen as well is where this is usually, for example, somebody who is just doing inventing on the side, really that startup, is using your employer's resources to develop the invention. Money may be tied or it's just convenient. My advice would be just don't do it. Beyond being unethical, there are serious legal implications to doing so. So, for example, you may have inadvertently given your employer certain legal rights to the invention. So it's always important to keep that as separate. The other pitfall, I would say as well, would be not assessing the landscape before and during product development. And basically, sometimes some individuals end up walking into somebody else's patented technology, and essentially they get basically surprised by getting a cease and desist letter. So it's very important that you are aware of really what space are you operating in and making sure that you're not inadvertently inventing on top of somebody else's invention. So I'm gonna stop there so that we have time to have a discussion. Ale, did you have any questions?
So I am gonna open the floor for questions. So you can either go ahead and submit your question by using the chat or the Q&A, or you can, if you'd like, you can raise your hand and I can unmute your microphone. We'll see if anybody has any questions. So we have a question, right? Randy, you can go ahead and ask the question.
Okay, thank you. I was just wondering whether you recommend to file after all the design details of potential claims are determined, or just trying to understand what the initial filing does and when to do it.
So if I'm understanding it, you're saying whether or not to file when the invention is completely fleshed out in all details, or just a general concept?
Yes, whether to flesh out all the details or as much as possible before filing or meeting with an patent attorney.
So I would say once you've kind of conceived the idea, and maybe even one embodiment, you can go and talk to a patent attorney at that point. You don't have to perfect the invention before filing, right? So I would say kind of, for patenting, you don't, reduction to practice is, and I know we kind of moved away from conception and reduction to practice. Now we're kind of first to file in the US as of, passing of AA in 2016. But it's important to, I would say, not wait too late. So once you've really kind of developed the invention to the point where you're like, okay, this works, and you have even one iteration, you don't have to flesh out every single detail, but the information, the data that you would have gathered would have been able to give you the information you need to be able to extrapolate the rest of the features of the invention. That's a good time to actually start talking to a patent attorney then, and then they can tell you, okay, maybe we need to flesh out this other part. But at the very least, you can file a provisional application, right?
Okay.
And then you have 12 more months before you convert it. And usually when you file a provisional, it kind of sits at the patent office, it's not examined. And this happens a lot of time where, maybe the technology is relatively like new and not fleshed out. They probably don't even have an embodiment completely reduced to practice. You can file a provisional on that and then really kind of create a framework so that as the data is coming in, because maybe you actually plan to run a series of experiments, as the data is coming in, depending on what the data is look like, it may make sense to file another provisional application to capture it, depending on what comes out of that, or simply just kind of include this extra data at the time of conversion. So then you don't need to file a second one, because essentially you're setting out the invention in such a way that as the data is coming in, it's just filling in the gaps that you created these, I call them toe holes when you draft, right? Once the data comes in, we kind of say, okay, that substantiates this area that we said that we would have this feature of the invention.
Okay, that's helpful. And once you file, is that public? Is that what you call public? Does other people see that you filed, or is that not true?
So when you file a provisional application, it's secret.
It is secret. Okay.
It's secret. What happens is you file a provisional application, it's not examined, it sits at the patent office, and then you have up to 12 months to convert it. So once you convert it, if you convert it to a non-provisional, which is like the next step in terms of the under 111, once you convert it, then it goes into active prosecution, right? The patent office processes it, assigns it to an examiner, and then it gets searched, and they start to evaluate patentability. And that publishes. If you go, once you convert, approximately 18 months later, it goes public, right? Unless you have filed with the patent office a non-publication request. If you go PCT, it also gets published also after a certain period. Usually I think about a year or so, it will get published. But for the provisional, that first case, it does not get published at all.
Okay, that is really helpful. And to create the provisional, do you recommend going through a patent attorney to file, or no?
I do.
Okay.
I do. No, there is no requirement that you have to have a patent attorney. People can, file your own case on your own as a pro se kind of inventor. You can actually do that. But I think what happens is that a lot of times inventors who are not, this is not really their area, that this is not their wheelhouse, they run into a lot of problems because they don't really understand all those intricacies of patent law. And so, and that's kind of really looping back to my earlier statement. A lot of times money is tied, and so people are like, I'm just gonna just do this on my own, or because there are a lot of patent services online that they're like, we can do it for $500. And then what happens is that 2 years later, you actually get an investor who's like, oh yeah, this tech looks good. and you're like, oh yeah, I have a patent application, and you give it to them and you're like, oh my God, no, this is not going to work. And because you already have something out there, you can't go back and refile.
Okay.
Because it's at that point it's done, you know. And so like it's important to if you really are serious about kind of getting that technology to commercialize, you want to make sure it's done well from the beginning. And the challenge when it comes to patent services is that inventors typically, you can't really tell how well it's done. That's the challenge. So if you, even if you went to some unknown quantity online that charge you a lot of money and you're like, okay, it's expensive, so it's a good quality, you won't know the quality of it until somebody else takes a look at it and say, oh yeah, it covers it, or oh, it's well drafted. And that makes it actually very difficult, because as an inventor, it's hard for you to tell if it was done well.
Yes, thank you.
Yeah, you're welcome.
All right, thank you. Those were really great questions, Randy. We have a few more questions that were submitted via the Q&A anonymously. So the first one is, I know you won't like this question, but if you work with a patent attorney to write parts of the patent, what can you expect to pay for a startup? A range?
It's hard to say. Sorry. It's definitely hard to say, because it depends, you know, in terms of patent application, it depends on the length of the case, right? So I would say maybe ballpark range, I would say at least maybe 3 and up would be my expectation. But as I said, you know, there are a lot of firms there that, you know, if you help to draft up parts of the case, then, you know, that's less work for them. That's less time for them to actually write anything. Do you know what I'm saying? And so in that regard, you help to kind of hold the cost down, you know. And there are some firms that will say, well, I'm not doing that. But there are many other firms that will do that, because they've worked with smaller companies, and reality is that at the beginning, you probably don't have a lot of funds and you don't want to spend a ton of money at that going, you know. Maybe when you get an investor and get some kind of funding, then you're able to really kind of have more budget. So, you know, in a lot of ways, you know, I tell my startups is like, file a provisional, the clock is running, you need to find some money by the time you get to 12 months so that you can be able to really flesh out that case. And certainly, you know, if they, you know, once we get to conversion, and people do, for example, some companies may have enough money to be able to file a PCT. I say you have 18 months. You need to get some real money by then, because, you know, once you go international, it's a lot of money, and you want to make sure you have somebody footing that bill, because it's going to add up very fast. And so I would say at the end of the day, you want to make sure you need to find a firm that they understand the realities of really what startups have to go through, and really that kind of financial reality that they have to navigate. So then they can kind of work with you and really be able to guide you through the patenting process. But I'll be frank, patenting costs money. And if it's something that you're like, well, I do want to spend a little money, I would say just you may want to rethink the entire venture, because it's going to cost you money in filing fees. I mean, the patent office has been really good about keeping the fees down. As I was telling one of my clients this morning, now the discount went from 50% to 60%. So that's a good thing, right? For example, for small entities. For micro entities, I think it went from 75, I think, to 80 or 85%. So on the patent fees on the US side, it's definitely better, it's cheaper, right? But overall, for the patenting process from day one all the way to getting a patent, it's going to cost money. And so I would say for somebody embarking on patenting, to be frank, that's something that you don't want to take lightly. It is truly an investment. And it has to be approached as that. I mean, I would not go and get a patent just because I want a patent, right? It has to be commercialized or monetized or something to get a patent, because it's an investment.
Thank you. And the same person also wanted to follow up. Three what? I assume $3,000. I guess that's what you meant. The $3,000.
Yes. My apologies. So yes, it would be. I would say that would be my ballpark would be probably around 3.
Okay. Yeah. Thank you.
And up, because if it's a complicated case, even if the inventor were to assist with the drafting, it may actually require a lot of attorney time to get it in a fileable form, and it may require a lot of back and forth in terms of strategizing on how to best protect the inventor. There may be more involved. So I would say baseline probably somewhere roughly 3 would be my guess. But you won't be getting, if you're like $1,000, I highly doubt that, and I would be skeptical, to be frank, if somebody would be able to do that for you for that kind of money and do a good job. That's more important, to do a good job on your application.
Yeah. Thank you. Another question is, can you see a provisional patent once an application is filed based on the priority date of the provisional? Doesn't it become part of the record?
Okay, can you repeat the question? I'm sorry, I missed.
Sure, sorry.
I want to make sure I understand.
Can't you see a provisional patent once an application is filed based on the priority date of the provisional? Doesn't it become part of the record?
So I would say that once it's published, once it's published, the key will be publication. Once it's published, then the full priority chain can be seen at that point. But before publication, the only people that can actually see that would be the attorney of record, or if this was filed by the inventor will be able to see that through, for example, USPTO's portal, like Patent Center. They'll be able to see that. But just a random member of the public, no. It has to be published first.
Right, and then from what I know, my understanding is that it publishes 18 months after the full application is filed. Correct?
Yes, roughly 18 months. Yes.
Yeah. So to answer this question is, you can file a provisional, and then 12 months later, it's still going to stay closed and not published. Then you can convert it into full, and then it's another 18 months until it's going to be published. Is that correct?
Yes. So, and again, with the caveat that, you can have a non-publication request. So for example, if you're looking at, let's say, some kind of competitors' IP, they may have filed a non-publication request. So you would have never seen that thing until it issues as a patent. That could be years later. But from the moment you file, if it's going to be a provisional application from the very beginning, it would be about 2.5 years, from provisional, then non-provisional, before you'll be able to see anything at all. But once it publishes, you can be able to see what the priority chain looks like. And that's where you'll be able to see that priority provisional application.
Yep, got it. Thank you so much for that clarification. I don't see any other submitted questions or raised hands. Does anybody else want to raise their hand and ask a question or submit it? And if not, we can thank our speaker today. Thank you so much. This has been a great session, and thank you to everybody who submitted questions. I think it contributed enormously to the discussion. I'm sure there are a lot more nuances that you didn't have time to share with us. All right, so we have a raised hand. Go ahead, Randy.
Yes, thank you. I just was wondering if you could touch on the global protection and just quickly on that process, how that differs from the US, because I was just wondering about that.
So as I mentioned before, so you have You have the provisional application, right? And then you have 12 months to convert to domestic and or, okay, some people do domestic and foreign. I mean, domestic and PCT, I should say, international. Some companies do that for strategic reasons. But for the average person, like a startup, I would say just file the PCT, save your money. I wouldn't, unless there's a real pressing business objective, it may not, I don't think it would make that sense to spend extra money on that. Just go PCT. And from the PCT, what happens is that you have another 18 months. And then at that point, you can choose to enter national phase in the countries that have signed on to the Patent Cooperation Treaty, which is, I would say, most countries, at least most of the major jurisdictions have signed off on that treaty. And then what happens at that point is that you would have to file, or rather, we would file a request in the jurisdictions that you want to pursue, right? Now, before I go into more detail on PCT conversions, I would say there are certain jurisdictions that you cannot go via PCT. So for example, Taiwan, if you wanted to go in Taiwan, then you would have to direct file at the 12-month mark. You couldn't actually file PCT and then kind of wait later on. It would be at the 12-month conversion mark that you'd actually have to file there. And there are a handful of other countries that fall in that category as well. But I would think the short list is maybe, 3 to 5. It's not a lot of countries that you direct file. Most countries you can go through PCT. Now, for the national phase, that's really where it starts to add up in terms of cost. I would say one of the biggest fees you end up paying for is translation costs, because each jurisdiction is going to require, that's not in English, typically requires that you translate into the local language to be considered by their patent office. Europe is a little bit different. You file before, for a conversion, it gets examined by a European Patent Office. And then once you have a patent, then it would become essentially nationalized into the individual European countries that are part of that block, where you'd actually want to have your patent protection. But that kind of international stage is actually, it's expensive, which kind of goes back to my earlier comment that, for startups, I tell, as I said, the moment you start filing that provisional, the clock is ticking. You need to find money. If you don't have money already, you need to go and find money, because what ends up happening sometime is you don't have enough money, and then basically you end up not being able to nationalize. So you end up just nationalizing just in the US, and you never get to go abroad because you don't have enough money. So it's important that you actually have the funds to be able to go in the individual countries. I would say you wouldn't just go any individual country abroad. There's a strategy behind it. For example, you'd want to probably nationalize in countries where there's a market for the technology that you're trying to commercialize. Doesn't make sense to nationalize in a country where there's no big market, so you could sell that product there, right? You also would, for example, want to nationalize in countries where maybe that's where you're going to manufacture the product or practice that method, things like that, so they can be certainly strategic. I don't see people filing, for example, in like 10 different countries. The only time you see that kind of thing is usually like a very big company, maybe like it's a drug, and they kind of across the board, because it's a product that has like a large global reach. Then it kind of makes sense that you're really filing everywhere, that you can think of, because they know they're going to have commercial activity in these jurisdictions. But for the average startup, it doesn't make sense to do that. It would be more of really sticking to the major markets, so that when you're going for that kind of investment, then you can say, okay, we do have, let's say, for example, you haven't got money until it gets to the national stage. You can say, okay, we would have patent protection in the major jurisdiction with the biggest markets. And so our portfolio is attractive. So hopefully that helps.
Yes, thank you. Thank you very much.
Thank you, Keisha. This has been such a fantastic session, and looks like we are almost out of time. So I don't know if you have maybe a few parting words in conclusion, and then we
So I
can.
would,
Yeah, go ahead.
no, thank you, Elaine. I would say, I mean, you know, kind of going back to what I started with, I would say my parting word is, you know, launching a startup is tough. I know this as an entrepreneur myself. But you want to make sure that, you know, as you really invest all of the time and energy into really kind of making your invention a reality, that you kind of make decisions that's going to, you know, further your objectives and goals. And certainly it's better that you have one really good patent than you have 5 ones that don't make any sense. So I would say, don't be penny wise and pound foolish. Make sure you find, you know, kind of a trusted IP advisor, somebody who has some experience working with us with startups. So again, they can give you guidance, like, you know, not because it's a big name necessarily means that they're the best fit for you. So you want to make sure that you do your due diligence before you pick someone. Don't just go on the internet and pick a random person, because I've seen many people burn that way. So that would be my advice to you.
Thank you so much, and thank you to everyone who showed up and attended and stuck to the end. We will be posting this on Startup Unity YouTube channel, so you can watch this again in case you think that you missed something or would like to a refresher. So, and again, thank you so much, Keisha, for spending this hour with us today and sharing your insights based on your own experience and your expertise. Thank you.
Thank you, Ale. Thank you for having me, and happy to help.